A preliminary hearing in California is actually the first opportunity for a criminal defendant and their attorney to actually get a great view of the evidence, look at the evidence, and more importantly, attack the evidence. A preliminary hearing is an evidentiary hearing that normally occurs or should occur within 10 court days of the person's first appearance in court. It could be concluded within 60 calendar days of a person's first appearance in a California court. A preliminary hearing, the district attorney has the burden of putting on evidence to show by a reasonable likelihood that a crime has been committed and that the defendant has committed that crime. It's an opportunity for a lawyer like myself here in Southern California, specifically in the Inland Empire, to have a chance to look at the witnesses, ask the witnesses questions, whether they be law enforcement witnesses, detectives, investigating officers, or private citizens, what we call lay witnesses. On occasion, in a preliminary hearing, we also have an opportunity to cross-examine expert witnesses. An example of expert witnesses that could testify at a preliminary hearing would be toxicologists, pathologists, doctors, nurses, reconstructionists, gang experts. The standard of proof, however, in a preliminary hearing is not the same standard of proof that the district attorney would have to prove at trial. For example, at a trial, the standard of proof is beyond a reasonable doubt. To sort of quantify that, if you looked at the scales of justice like this, beyond a reasonable doubt, the DA would have to show so much evidence at a trial, it would look like that. At a preliminary hearing, the evidence is just a preponderance or a small likelihood. So picture a feather going on one side of the scales of justice and moving the other one just like that. So the burden to hold someone to answer, or what we call bind someone over for trial, is very minimum. The district attorney just has to prove a minimum amount of evidence so that a person can be bound over for superior court and ultimately for trial. Never discount, though, the importance of a preliminary hearing for the lawyer to evaluate a witness, both on not only what they say on the stand, not only the facts on the stand, but how they may present themselves to a jury. Oftentimes, we're able to get a complete picture and evaluate a matter by going through the preliminary hearing process. There are many devices after preliminary hearing that would allow us here in California to attack the evidentiary standard and bring motions to dismiss the case. Recently, we had a preliminary hearing where our client was charged with 5 felony counts of defrauding a homeowner, grand theft, and contracting without a license. After review of the evidence, it was our opinion, based upon the totality of circumstances, that our client, in fact, was not guilty of felony conduct, and at worst, this matter should have been litigated civilly. We tried to work out a resolution with the district attorney. Ultimately, we went to a preliminary hearing before a San Diego County Superior Court judge. After 4 hours of testimony, the court agreed with our position and would not bind our client over for trial for felony matters. That matter ultimately resolved for our client pleading guilty to an infraction and paying a small fine. It was certainly a rewarding matter in that the district attorney overfiled the matter. We were able to convince the judge that our position was right, and needless to say, to a very grateful client. I'm Mike Scaffidi, a retired police officer and now a criminal defense attorney with Schaus Law Group. If you or a loved one are in trouble and need help, call me.